Mr. Speaker.
Sarah Dowie.
Well, thank you, Mr. Speaker, and I rise in support of this private international law choice of law and tort bill in its first reading, brought to this House by Mr. David Bennett. Mr. David Bennett, the dairy farmer of this House, I understand has completed a law degree, chair of the Finance and Expenditure Committee, Select Committee, and now lover of torts. I never knew this. Obviously majored in tort law in your law degree. An absolute lover of torts and passionate about clarifying this rule around double actionability. And how impressed I was coming back from Invercargill today from the Southland Regional Development Strategy launch, where this government has swung in behind our strategy team leaders with millions of dollars of investment. When I should have been coming back on the plane, basking in that glory, here I was racking my brains from 1995, thinking about tanks of water that had burst and run into a neighbouring property and caused nuisance, and a woman who had swallowed snails while drinking ginger beer. Other words, these cases are known as Rylands and Fletcher and Donoghue and Stevenson. And I had real trouble remembering that last one, but it's Donoghue and Stevenson. And that's how hard I had to work to rack my brains about torts that I studied back in 1995. And I don't feel so bad now after Mr. David Parker's speech, because I too had real problems with torts and with this double actionability rule. Could never understand it. And I think it's been described in some of the literature as difficult to understand. So I'm pleased that Mr. Bennett has brought this bill to the House to look to clarify and codify this law. Oh no, Ms. Dean, I do not want to come onto the committee with respect to this bill, but I'm sure I'm at the mercy of the whips. And torts, well, I mean, as we are aware, it is about private actions. It does illustrate the importance of case law, that obviously case law develops these important laws in our legal system. But the issue remains that it is difficult to understand when an action occurs in a foreign jurisdiction as to which actual jurisdiction applies. So this is a bill that clarifies which jurisdiction of law is applicable to torts and provides guidance to the courts on matters of characterisation. So one of the great things, as I mentioned before, is that it abolishes the so-called rule of double actionability, and I'm going to have to refer to my notes with respect to this rule. When a tort claim is brought in New Zealand for an action committed in another jurisdiction, the New Zealand court can hear the claim only if the tort is actionable in both jurisdictions. It then must apply New Zealand law unless the other country has a more significant relationship with the occurrence and with the parties. Excellent, Mr. Bennett. Thank you very much for that. That will clarify things. I think it's only wise and proper that if an action occurs in New Zealand, then our law should be applied, and if overseas, then that jurisdiction should apply. And I think that the rules set out and the principles set out in this bill will actually clarify that, codify it, and make it easier for young lawyers as they come into the legal profession. So as this bill has been described, it's a no-frills bill, but look, backbenchers don't need bells and whistles when you're working for the government. So it's a no-frills bill, but it's pragmatic, and it's a good bill, and it's solid, and I congratulate Mr. Bennett for bringing it to the House.